Now, the last is yet to be heard on the decision by the Lagos State government not to prosecute Dewan College, some suspected students and staff for alleged offences ranging from criminal negligence, murder and cultism regarding the death of young Sylvester Oromoni. TVC News correspondent Kemi Fola Adeyemo sought legal opinions on this controversy and now reports.
According to the Lagos Ministry of Justice, the young Sylvester was taken to the sick bay at Dewan College between the 21st and 22nd of November 2021 after he allegedly suffered injuries while playing football with his friends. On November the 23rd, the school released him to his parents for further medical care. They took him to Warri, Delta State on November the 26th, where he was treated at home by a family doctor. While at home, Sylvester reportedly revealed the names of some senior students who allegedly tortured him and forced him to drink an unknown substance for refusing to join a cult. His condition worsened. The family then rushed him to the hospital on November the 30th, but he died on the way. Amidst the public outcry, the police arrested 5 students and 5 school staff and brought them before a chief magistrate's court in Yaba on December the 21st over the incident on charges of conspiracy and homicide. As it is administratively mandated for serious crimes as this, such as felonies, which the magistrate court cannot handle, the case files were sent to the Directorate of Public Prosecution at the Justice Ministry for legal advice. On January the 4th, 2021, the office of the DPP responded that it wouldn't charge the suspects as there were no facts linking them to the alleged offences. It also stated that the outcomes of 2 independent autopsies done on the deceased were in agreement as to the cause of death, which includes severe sepsis, a serious medical condition caused by the body's response to an infection.
Still living God, we are very detached of my son, Sylvester Oromoni Junior. For this, the whole world will know that there is God that fights for the oppressed.
This is just the beginning of the matter. If God keep me alive for the next 30 years, if I don't have justice, this matter will drag for the next 30 years.
If they open this school on Monday, the whole Nigerian nation will come, we will carry our school bags, we will carry our feeding bottles, we will carry our food, we will join them in the school. Let them bring armor tank here, let them put armor tank one here, one in the back gate, one in the hostel. We have the capacity. We will, if they don't give us justice. When this happened, we said, okay, we want justice. We fold our hands. It's the first time in the history of this world we are hearing that before an investigation was concluded, before a case that have gone to court, these suspects are under bail.
But the senior advocate of Nigeria calls for objectivity on the decision of the DPP, who represents the Attorney General of the state. He also explains why the suspects couldn't have been tried in court upon the close of police investigation.
The law is such a way that you can only charge someone to court if you have a prima facie case against him. If you don't have a prima facie case against him, it cannot create the burden, the inconvenience, the cost of putting him to trial. Because, let's face it, to put anyone to trial for murder has its own huge economic and social implications. So the state has to, first of all, filter the evidence. The Attorney General has to filter the evidence and take a decision where there is a prima facie case. If there is a prima facie case, then he will not charge the matter to court through an information, and they will now be arraigned before a court, and then the trial will go on. Then the judge will decide on the basis of beyond reasonable doubt whether they have proved their case.
Mr. Obiagu also adds that the Attorney General can still reconsider his decision if new evidence comes up and is presented.
The decision of the Attorney General not to prosecute can be challenged on 3 grounds. 1, if there is malice. If there's evidence of malice, there's evidence of fraud, or it is completely against public interest. So if you cannot establish malice or fraud, then it is difficult for you to challenge the decision of the Attorney General. So if there is new evidence from the family, for instance, they can turn it up to the police for them to update the case file and submit to the DPP. But the point is that justice in this case must be looked at from a broad perspective. It is very unfortunate that the young boy, who lost him, but there's also a lot of people whose reputation and integrity and life are at stake. So their interests also have to be taken into consideration. And the point, and what the Attorney General is saying is that you have not presented sufficient evidence for me to put them to trial. Perhaps go back and do your investigation and produce more evidence. It is not the end of the case, as a matter of fact.
For now, the Oromonis, through their lawyer, Kemi Fola, a senior advocate of Nigeria, are still pursuing other legal options. On January the 4th, the Chief Coroner of the state, Justice Mojisola Dada, in response to the family's request on December the 6th last year for an inquest into the tragic death, announced that open hearings will start on January the 15th. But this procedure, a creation of the laws of Lagos State, is only set up to inquire into a death for better understanding and not to ascertain guilt or fault of anyone, as that power only belongs to the regular courts. Kemi Fola Adeyemo, TVC News, Lagos.